Good evening and welcome to another episode of Law and Order. In our previous episode, we discussed about administrative law, which is a very vast area that we went into a lot of details. And today also joining me to discuss more about administrative law is Mr. Astika Devendra, attorney at law. A very good evening to you, Astika.
Good evening.
I can remember that we did wind up things last time on the topic of how a judicial part can come into play in an administrative law suit case. And also we talked on a topic saying, can the state be challenged in terms by a person in terms of administrative law case? We want to start off from that.
Yeah, yes, Kosala. It's like this. Now, the administrative law, as I think we discussed last time, is where in how basically the state treats individuals and how the individuals deal with the administration of the country. So officers, institutions, so on and so forth. Now, generally, if you are harmed or you are damaged by a particular person, for example, if you damage my property, my body, my car, whatever, my house, anything, the general remedy is damages. That is, we are go to the district court and say, look, this person damaged me and compensate. But the important factor is now state institutions cannot be facing litigation day in and day out. Right? If people were to go to the district court and ask for damages, nothing will get done. Right? All the officers will be in courts because they have to face litigation. So that has been barred. There are certain exceptions. If a public officer has acted mala fide, of course, there are certain exceptions, but generally you can't go to the district court. So you have to go to you have to go for judicial review. Now your question is whether a state can be made a party. My answer is a state in a judicial review matter or a writ application, if you want to simplify it, state is a necessary party because you are in fact challenging. For example, let us say you and I want the same plot of land. Let us say we were siblings and my father had that plot of land which was a government grant, and now we are fighting over it. The divisional secretary says, okay, I am devolving title to you. Then in an administrative court or in a writ court, I can't file case against you. You are a party, but my grievance or the person who have made the decision, that is the divisional secretary, is definitely a necessary party. So the state must be a party.
So you cannot file a case against the state, is it?
You can. Definitely you can.
They need to be a certain party.
Then administrative law cases or writ cases is basically against the state. It's against the state.
Now, for example, if you take now, say for example, the electricity board comes into your house to do some repair and they do damage property, then the same thing can be applied. Is it like you can file charges and then you can take it through the entire process?
No, damages is a different issue. For example, if they have acted in a manner which they ought not to have and it has caused damages, of course, you can't go for damages in that sense. But for a decision that had been said, for example, electricity board coming and damaging your property in a way that you ought not to have is a different issue. But let us say a decision is taken to draw electricity line over your property, basically in administrative law, what you are challenging is that decision. You want that decision quashed. You call that a writ of certiorari. So that decision you have to make. The decision maker of that decision that you are seeking to be quashed is a government officer. You have to make that person a party.
So what are the grounds for a judicial review?
Right. Now, as I said, before coming to judicial review, that is before you come to the Court of Appeal, you have to first go through a process of adjudication, appeals and so on, right. So that particular party, who are not dissatisfied with that particular decision, now you come out to judicial review. Over time, certain principles have evolved. So I will elaborate this slowly because we are not addressing lawyers, but I think it is necessary for even the viewers to know this. One ground, there are three basic grounds which have been identified, but it has evolved and there are certain more, but I will elaborate some. One is there is a principle called illegality. That's very simple. That's the simplest form. If the decision that has been arrived at or decision which is going to be made is illegal according to law or regulations, then you have a ground. Then if it's procedurally improper, as I said earlier, there is a process, you have to follow that process. If that is procedurally improper, then that is a ground for judicial review. Third one is a broader one, that is if that decision is arbitrary. Arbitrariness is, let's say, 75 times of 100. If a person is put in that place who has the same skill and knowledge, that decision would not have been arrived at, right? I mean, if you ask 10 people, right, whether you would do it, only 2 people says that I will do it, the 8 people say no, I don't do it. So then that becomes arbitrary, and there are certain other principles like legitimate expectation. That is where someone promises you, look, I'm going to employ you. Let's say it's a employment. Someone promises you that I am going to employ you, and you forego something that was coming towards you, forthcoming to you. And then that person says, no, I am not going to take you in. So that might something be like legitimate expectation. Not giving a proper hearing, audi alteram partem, right? So these are the basic grounds which attracts judicial review.
Well, the other question, the common question that everybody asks is, how long would this process take? From the start to a judicial review, how long will this take?
That's actually a question that I would prefer not to answer, but I don't think that it's our court systems, for a lot of reasons. I mean, this is something that applies to civil cases, criminal cases, judicial review, commercial court law, commercial law, every aspect of the law. Because of lack of judges, infrastructure facilities and so on, we have a backlog. So the initial stages, of course, there is a timeline, but judicial review takes a bit of time. Sometimes it might be going into years, but if there is an immediate grievance of a party, you must know that in the judicial review process, as in all other processes, there is a remedy where you can obtain interim relief. For example, if someone has decided to demolish your building, that's an administrative decision saying that it's an illegal construction. Of course, you can go to the court and say, look, I'm saying this is illegal, until such time give an interim order staying the operation of that decision to demolish your property.
So it can the decision can be halted. For example, I'm building a illegal building, and then you complained against it, and so that can be prevented by an order given, is it?
Yes, either way. Now, so your example was different to mine. That is, if you are building something and I am complaining, I can go to court and say, okay, decide that this is illegal, until such time prevent him from building. The other way around, let's say you have now built the property and the authority comes and say demolish this property, right? And you are going to court. By the time court decides, if they have already demolished your property, there is nothing to go on, or the entire process will be academic. So in that sort of situation, if the court is satisfied, they will give interim relief in the form and say that no, until such time prevent this property being demolished. So that is one remedy that you have for this delay that we have.
So generally it will take more than between a period of 3 to 6 months to come into a conclusion, or it can take more, is it?
It takes more. It takes more.
Years.
Probably, yes, but hopefully, I mean, just before the pandemic, the 20th Amendment came into operation, and there was an increase in judges. So hopefully we are looking at some good developments, but still, because of the pandemic now, there will be a new backlog in Sri Lanka. So I don't think that will be expeditious.
That's an interesting topic there, because I was going to come to that later on in the program, on how the courts currently function in Sri Lanka with this entire pandemic situation going on. Before that, anything that you would really want to sum things up on administrative law before we go into how courts function and how citizens are faced with the pandemic with the law in Sri Lanka?
Administrative law, of course, is an area. I think this is the most important thing I want to say. The administrative law is something that Sri Lankan people lack knowledge of, and I think even at a school, because this is where you this is since this is part of public law, we elect a government, we select a government, we have a government. Now you know this is I'm going back to a very broader area, whereas we select the three segments of the government, the organ of the state, and say, look, you now deal with us, right? We have given them the power in different forms, the executive, legislature, and the judiciary. And now, once we give the power, we, in a way that we become inferior, because they make decisions on behalf of us. We get the chance to make decisions on their behalf on several situations only. Everybody needs to know what their rights are before you execute your right. I mean, we can talk about grounds of judicial review, but some people might not even know what the Court of Appeal is. So I think what are the most important thing? I mean, I don't think we can do it in couple of the, programs to educate. I think at school level even, at least some basic principles, how to guard your rights. People must be educated. I think that's the most important thing I can say about administrative law. I say that everyone should be knowledgeable. I mean, they might need not to be knowledgeable about many, they might not need to be knowledgeable about commercial law if you're not into business. You need not be knowledgeable about intellectual property law if you're not doing to be a new innovator. But this is aspect that you need to know.
Yeah, because that's very important, because let's say, for example, now if I come across a situation, now people sometimes, without going into the first step, now we talked about the grammar nilada, without going to the grammar, they take it to the higher authority, but then it again on the reverse, you need to go back. So I think that's the education, type of education that people require.
Exactly, because you know why. Now when you go to judicial review, that's good that you asked that. I was going to say that. Now you have to go, now you everybody, I think most of the people in the country know that if you want to find a fundamental rights application, you have to go within 30 days or 1 month to court. Judicial review, they say come within a reasonable period of time. Now what people do is, now they go through the appeal process, finally they are given a decision, and then they, without going to court, unreasonably they keep writing to people. Now, right? And so, for example, let's say someone has, we'll go to the same example, it might be boring, but drawing an electricity line, it may be easier. They take the decision to draw the electricity, final decision is given, it's going to go over your land. But sometimes effecting that decision might be in 6 months, 1 year or so on, because there might be other developments which are necessary. So this final decision is given, so they keep quiet. That person is also not, they might be writing to so many people, they might be writing to the His Excellency the President and so on. Suddenly when the electricity board comes to draw the line, they suddenly get activated and they come to lawyers and say, so what to do now, these people are going to, so when was the decision given? 2 years back. What were you doing? We wrote to the President, we wrote to so or so, but they didn't come also, so we didn't. So that is where you go wrong. So that is why education of administrative law is necessary.
Well, there you go. That is a brief detail of what administrative law and how it applies in Sri Lanka. Where you need to go, that's the most important. Where you need to start before you go into courts if you're having any issues with administrative law. So, well, I think we are all now facing problems with the ongoing pandemic, and a lot of industries, a lot of fields are on a standstill, or working in a different method, working from home, work virtually, a lot of things. How does the courts, or how does the law system currently is handling this whole entire situation in Sri Lanka with the pandemic?
Yeah, we have now, even before the lockdown, we were at a very disadvantageous situation compared to other institutions. Now, for example, let's take this institution. Generally, now I am the outsider here, but just one outsider, right? All the other people are people who you meet day in and day out, and if you get vaccinated and so on, I mean, there is no mixture. If one gets infected, then you know how to trace who are the people that he have associated with. But courts, now as an attorney, I can practice in any other context. For example, I have case in Jaffna, I have cases in Matara. So from north to south, east to west, I practice. The litigants come from all over the country, right? So this is like the Manning marker, where people get mixed together. So it was very difficult for courts to function. At this point of time, even before this last lockdown, 2 weeks prior, I think the courts basically came to a shutdown. Urgent, so I'll start from the lower hierarchy, that is the magistrate courts, bail applications, that's because crimes don't stop just because of a lockdown. When people are brought before the Lennon magistrate, he has to order bail. Bail applications are taken. Attorneys are allowed to represent them. Urgent matters in the magistrate court, you can file motions, whatever the urgency it may be, you can file a motion and get it called. District court also the same thing. Urgent matters, file a motion. High courts, bail applications, and urgent matters can be taken. The Court of Appeal, 5 days of the week, different branches of the court, the Court of Appeal are functioning. For example, writ applications are taken on one day, bail applications are taken on another day, so on and so forth. Supreme Court, if there are urgent matters, you can file motions and get the case called and make your application. So, at this point of time, which I am hopeful will change very soon, that is the state of affairs as far as the Sri Lankan courts are concerned.
Another thing that we heard and we got to know that is that there were cases being heard, especially maybe criminal cases or from prisons to courts on a Zoom system. Was there something like that happening?
Yeah, just before the last lockdown. So I actually did it. There were 2 criminal cases which I argued before the CCA, that is the Court of Criminal Appeal. Prisoners were not brought in, but the prisoners were in the prisons before computer and through Zoom, because there is a necessity under our law in a criminal appeal, where the accused appellant has to be present in court. So that was done away with by this Zoom technology. I mean, we were trying to find ways, not me, but the system, JSC and the Justice Minister was trying to find ways to somehow function in this pandemic.
Yeah. So now, when it comes to criminal cases, obviously we know that you need to have witnesses coming in. There's judiciary. There's a lot of things that come in. Now, so with this new technology, is it feasible, or is there any productivity, or can verdicts be given in a proper manner with going through Zoom and all that? Because for some cases, obviously you need witnesses, but then how do you bring in your witnesses?
No, it's like this. Now, we have seen in commercial cases, for example, if the witness is abroad and who is not willing or incapable to come to Sri Lanka, that technology has been used. Now, we have come across a pandemic which we never thought we will have to face, and I think we will have to find new ways of doing it. People who are used to this previous technology or previous way of handling things find it difficult, but Kosala, we have to, because you know the judiciary, if you am going over time, please let me know. Now, judiciary is one of the main branches of government. It's not a simple institution, it's not a factory, right? It's not something that you can close down and keep.
Yeah, and as I did mention in my startup, this is the field that you cannot change things. Like, you can't bring in, just because of a pandemic, you can't change the proceedings.
Exactly. I mean, the rights of the people are intact. Now, here we see the executives are taking decisions day in and day out. They are carrying out decisions day in and day out. So, how good, how bona fide the executive may be, the people who can keep the executive on check and balances is the judiciary. So, if the executive is functioning, it's necessary for the judiciary to function. You can't have a situation where the court structure, one of the 3 main branches or 3 main organs of the government, shut down. You can't. So, that's an obstacle that I think as a country we are facing. So,
how will the citizens be affected with this?
They are affected, don't you think? Now, I mean, I'm not going to go into individual situations, but we see people coming and protesting. Some people, now government takes X decision. I'm not going to talk about the decision itself. And we see on news people protesting, saying that this is that decision that was taken, let's say, to deprive something to the people in this country, is an executive decision, administrative decision. Now, where can you challenge it?
Going back to administrative law.
Going to administrative law. No, to go to administrative, you have to go to court. Not only to go to court, you must have access to a lawyer. Now, lawyers are not working. To go to the lawyer, let's say lawyer is working, the lawyer says, come to my house, they need a permit to go there. And people at this point of time doesn't have money. to go to the lawyer and pay him. So, the entire system is struggling.
So it's going to be you mentioned about the backlog. So the backlog intends to get broader.
Broader, it will get definitely broader, because for the past 2 years we have not been working properly. I mean, every effort that was made to reduce the backlog has now faced huge problems.
So Astika, on a note, like say, what are the suggestions that you would want to like give? How can obviously this pandemic situation might not ease off very soon. This might go on. We might have lockdowns. We might have various things. So how will the judiciary want to cope with this situation? Are they planning on any new methods of running?
Yes, it's like this. I got a message yesterday, I think, what the Bar Association of Sri Lanka has suggested to the Judicial Services Commission. Judicial Services Commission, as you know, is headed by the Chief Justice and 2 other Supreme Court judges, and the Justice Ministry. I can't stress this enough. I say that, I mean, if we are not going to end the pandemic soon, I mean, if we have to face the pandemic and we have to live with it, that's what everybody is saying. Even United States now are saying, okay, we are now looking at another variant of this. So that means we will have to live with it. I mean, we will have to. We don't have money, so we will have to. So we will have to be innovative. We just can't say, okay, pandemic, we are staying home. We will stay home. It's not just about people earning money. It's not just about lawyers having work. It's not. It's a broader thing. I mean, as a country, the judiciary should work, the judicial system should work, and I think we must be innovative. If, as you said, Zoom technology, if you can use it, you must use it. If you can, now in other countries, what you do is you have a time slot for a particular case. Here you fix 10 cases a day and then you get all the litigants to come in at that time. No, you have one case from 1 to 2, you let only the lawyers and those witnesses to come. That is how you should. I mean, we can be innovative. I think we can get through this.
And another thing that before we wind things up on our topic, that now appointments to the judiciary, obviously appointment of the Chief Justice, appointment of the Supreme Court judge, it also happens during this period. So with a lesser amount of workload towards these superiors, so how will they operate during this period? So for example, when you come to your retirement age, whether you serve much or not, you will have to sustain your retirement age, is it?
Yes, there is no extension given to judicial officers. I mean, there are exceptions to the Honorable Attorney General where they had been given extensions, but not to judicial officers. They have to retire.
On a note of how the entire judiciary system works in Sri Lanka currently with the ongoing pandemic, and what are the methods that they are trying to implement to make things proper, and as Astika mentioned, to try to curtail or bring down that big gap of the backlog. So it's going to be very a challenging time for everybody. So in general, anything that you would like to mention before we wind things up,
so hopefully, I think if as far as a lawyer is concerned, I think we must also be very we must be sensitive to the situation. For example, when people come to us for these days, generally we say people now generally today when I was talking to you, a person called and said, okay, I can't come out. What can you do about this situation? Now generally, if a client does not come to me and just give instructions over the phone, I will not act on it. So as lawyers also, I said, no, okay, I will act on it. I will send my junior and we'll get what you want done. So I mean, we must be sensitive, and all parties concerned, starting from the judiciary, the Honorable Attorney General's Department, private lawyers, the litigants, the accused, so on and so forth. I think we all have to work together for the system to function. That I can say.
That's a very important thing. Work together and make sure that the systems function properly. Thank you very much, Mr. Astika, for joining us on this very important discussion on today's episode of Law and Order. Thanks.
Thank you, Klaus.
Well, with that, we come to a conclusion of another episode of Law and Order. Hope we had been giving you very important information on how the judicial system at the moment is operating in our country. So, till we meet again with another episode of Law and Order, it's good night.